argue, the appellant may reserve any portion of that time for rebuttal. Counsel, please identify yourself for the record and let us know how much time you wish to have for rebuttal. Attorney Emanuel.
Oh, yes. Good morning. May it please the court. I am Richard Emanuel representing Haral Patel, the defendant appellant in this certified appeal. With the court's permission, I would like to reserve 4 minutes for rebuttal.
Okay, thank you very much. Senior Associate Justice McDonald will be our timekeeper. He will let you know when there are 5 minutes, 3 minutes, and your main argument is over. Whenever you're ready, counsel, you may proceed.
Thank you. This court granted certification on 4 questions. The first 3 questions all relate to the admissibility of a dual inculpatory statement. We are challenging the admissibility of that statement on federal constitutional grounds, state constitutional grounds, and evidentiary grounds. In the 4th issue, we challenge the trial court's exclusion of a statement against penal interest that would have been exculpatory to the defendant. Now, ordinarily, I would begin my remarks this morning by focusing on the primary purpose test first articulated by the United States Supreme Court in Davis versus Washington. But I feel that it's incumbent on me to address a preliminary point first, and I will try to do it quickly in about 2 minutes. In the opening pages of the argument section of the state's brief, the state seems to suggest that our federal constitutional claim has essentially already been rejected by the United States Supreme Court. Now, the state makes that claim based on the fact that in both Crawford and Davis, the U.S. Supreme Court cited to 2 older cases, Dutton versus Evans and Borjali versus United States, as cases in which the hearsay statements were clearly non-testimonial. And we agree with that. However, in Dutton versus Evans, which involved a 1-sentence statement from one inmate to another, and in Borjali, which involved the defendant talking to someone whom he did not know to be an undercover agent, each of those hearsay statements was offered into evidence and admitted into evidence pursuant to the co-conspirator exception to the hearsay rule. Now, why is that important in our view? It's important because the U.S. Supreme Court in several cases has said that co-conspirator statements are part of the res gestae. They're part of the crime. They're part of the ongoing conspiracy, and therefore, due to their inherent nature, those statements would never qualify as testimonial under the primary purpose test, which is a backward-looking situation where you're trying to prove past events. And in fact, there's one sentence that I'd like to quote from Crawford.
Attorney Emanuel, before you go forward, if you could just hang on right there, Justice Ecker has a question.
I understand your point, Mr. Emanuel. This is slightly different, but it sort of follows, I suppose, from what you've just said. Has the United States Supreme Court ever found that a statement to a non-police officer or a non-law enforcement person is testimonial in nature for Crawford, for Confrontation Clause purposes?
I do not think the U.S. Supreme Court has ever definitively had to make that decision, but in Ohio versus Clark, 2015, which is really the most recent confrontation decision, they've indicated that they have not adopted a categorical rule saying that statements to non-law enforcement persons could not qualify.
Right. Okay. I was thinking of Ohio, that case specifically, because it sounds like they're expressing a little skepticism. I mean, you may be right that they've never, the Supreme Court has never definitively said, the Beaujolais point, but in this context, but they've come pretty close. I guess is my point. They've come pretty close to ruling out these being confrontation testimonial statements at all, haven't they?
Well, in our situation, we have someone who's acting as a quasi police officer. This was a state-initiated operation. So even if the Supreme Court were to say it has to be to a police officer, our situation would qualify just like the court has indicated that, a statement made to a 911 dispatcher might qualify as, as a statement to a police officer. So I'd just like to cite that one sentence from Crawford, where Justice Scalia, the author of the opinion, says, most of the hearsay exceptions covered statements that by their nature were not testimonial, for example, business records or statements in further of a conspiracy. And then on page 58 of Crawford, the decision points to Lilly versus Virginia, which involved a dual inculpatory statement against penal interest, as an example of a statement that was testimonial. So now I'll focus on the primary purpose of Michael Calabrese' statement. I'm not sure if the court wants me or needs me to go over the essential circumstances of this. Yes?
Counsel, can you turn your volume down a little bit? You're overwhelming the system. And Justice Khan has a question.
Thank you, Chief. Counsel, my questions are, I have similar questions to Justice Ecker. I agree with you. I also noticed that in the state's brief, they sort of seem to rely on pre-Crawford cases and suggest that Crawford didn't change the law when it was in fact a sea change of how we treat testimonial statements. It basically changed the analysis from an evidentiary one to a due process, constitutional due process. But didn't even in Crawford, and particularly Justice Rehnquist in his concurrence, indicate that certain statements, for example, co-conspirator statements, would not implicate Crawford at all? They sort of carved out certain categories to kind of reassure litigants in the courts that while this was a major sea change, certain statements would still come in. Would you agree that even in Crawford, the court clearly sort of carved out certain things that would be absolute or almost absolute exceptions?
Yes, and I think statements in further of a conspiracy is one of those categories. Dying declarations, I think, is another one of those categories. But we know now from subsequent cases like Davis and Michigan versus Bryant that the primary purpose examination involves a combined inquiry that looks at the motivations, the perspective of all parties to the encounter, which means you have to look at the situation from the perspective of a declarant as well as from the perspective of the interrogator or listener.
Okay, so I agree. focused on co-conspirator statements, which are statements made in furtherance of the conspiracy, whether they occur while the conduct is happening or even post conduct. Some statements made after an event could still be in furtherance of the conspiracy. But I took your argument to be that this isn't a true co-conspirator statement. This is more a statement against, a statement against interest, a penal statement, basically, by one co-conspirator, which implicates two others. And looking at that, I want to get to the issue that you just raised. What cases exist? I know that the Supreme Court and other federal courts have said sometimes you have to look at other things besides why the declarant, the primary purpose, why the declarant was making the statement they were making. But even if we assume this isn't a true co-conspirator statement, but a statement against interest by a co-conspirator implicating the defendant, don't we still look at what Mr. Calabrese thought who he thought he was speaking to, and for what purpose? What evidence do you have? What evidence do you have that Mr. Calabrese thought he was speaking to anyone sent by law enforcement? I don't disagree with you that clearly Mr. Early was acting as an agent, right? As law enforcement or an agent of law enforcement. But what evidence do we have that Mr. Calabrese understood that?
Well, I think we have to keep in consideration the fact that the analysis is objective. So a reviewing court cannot just look at the personal or subjective motivations of Michael Calabrese. You have to look at the quote unquote reasonable person in the circumstances in which he found himself. And I think you have to even go one step beyond. You have to look at him as a reasonable inmate, because in Michigan versus Bryant, when the U.S. Supreme Court was considering motivations of a victim, they addressed it in terms of a reasonable victim. So let's assume that the court has to look at this from the perspective of a reasonable inmate. Now,
but so that gets me to sort of my last question, because I don't want to take up all the time. It seems to me that what you're asking this court to do is to adopt a new test that focuses on the listener, the purpose of the listener versus why the declarant made the statement. So in that case, and you seem to make that argument when you get to the state constitutional claim that you raised. But I don't see that there are cases that support adopting a different test for what makes something testimonial or not. Now, I understand that there's some perhaps concerns about how Mr. Calabrese's statement was obtained. And I take it he pled guilty. So I assume, but correct me if I'm wrong, did he ever challenge his statement on the basis that he may have been represented at the time? That his cellmate was wired and sent in to get a statement from him?
Yes, there was a motion to suppress filed by Michael Calabrese's attorney, but he did not have a Sixth Amendment claim because the Sixth Amendment is crime specific, and he had not yet been arrested for the case in Sharon. He was incarcerated for violating probation in connection with a drug case.
Okay. So that was a point of clarification that I wanted to make. And I know that your client obviously doesn't have standing to challenge that same issue. But my question to you is, what support do you have for adopting this listener test that you're asking us to adopt?
Well, I would suggest that in terms of our federal constitutional claim, we're not asking you to do anything different than follow U.S. Supreme Court precedent. Bryant makes clear that you have to look at the statements and actions of both parties to the proceeding, the declarant as well as the interrogator. In fact, in Bryant, the petitioner, Mr. Bryant, his attorneys asked the U.S. Supreme Court to adopt a declarant-only approach. But Justice Sotomayor, writing for the court, and 7 of the justices rejected that claim. Justice Scalia dissented on that point. No one else signed his opinion. He thought it should only be a declarant-focused approach. But so looking at this from the perspective of the declarant, as I indicated earlier, I think you have to call him, a reasonable inmate. What would be the expectations of a reasonable inmate? Now, I am not an expert on prisons. However, in my career, I have made several hundred visits, professional visits, to meet with inmates, and that's not an exaggeration, over the course of many decades. Based on my experience—
Counsel, I don't mean to interrupt your answer. I will let you finish. I'm just interrupting to tell you, at least for me, I'm not hearing you. I'm going to mute myself. I'm done with my questions. I see Justice Doria has his hand up. When you're finished answering, I would defer back to the chief, okay? But just so you know, I couldn't hear part of your answer. I apologize. I'll mute myself. Perhaps that will help. And I'm done with my questions, and thank you.
Okay, I am very sorry about that. This is a learning experience for me. It's my first argument online, and it's much more nerve-wracking than being at the podium in the Supreme Court courtroom. Just to finish my thought, based on my experience of several hundred visits with inmates, every inmate is aware of what I would describe as the prison version of the second Miranda warning, i.e., anything you say in jail will and can be used against you in court by another inmate who's looking to get a time cut. I don't know if that's in the inmate handbook, but every inmate knows it. And in this case, Wayne Early testified. He was being cross-examined by Attorney Dow, and he asked Early, "Do you have any idea why Calabrese is talking to you about this?" And Early says, "It makes absolute sense. I've been in prison for a long time, and everybody talks about their crime." And then he goes on to say that even though there's a possibility of someone snitching you out, and Early says yes. So it's interesting. There are differences in many of the cases that look at the declarant's perspective as to whether a declarant would believe that the statements could be used against him, or whether the statements could or would be used against him. It reminds me of the different mental states in our penal code, where intentional conduct, conscious objective.
Attorney Emanuel?
Yes?
Sorry for cutting you off, but there are other questions, and including there's a question from Justice Doria at the moment.
Thank you, Chief. Well, on that theme, you seem to be developing a theme, I guess, that suggests that according to Mr. W, that Calabrese's statement would have some reliability because people talk all the time about their crimes unfettered. Although with all of the warts that go along with that, they may be puffing, they may be, trying, whatever it is. I want to focus you on the Declaration Against Penal Interest for this reason. I hope I haven't missed your drift in your brief about the factors that you focus on, inconsistencies in his statement and the like. what particularly do you see as undercutting the reliability, trustworthiness of the statement Calabrese is making as to your client? I mean, it seems undoubted that Calabrese did this. And so what door he went through, or whether he had a partner or what have you, where he shot him or everything. I mean, that may be important, but I take it from your defendant's perspective, the question is whether my guy was there or not. Calabrese clearly, that's going to come in, it would come in against him. But what's unreliable as it relates to your client?
Well, I don't think I can point to any individual facts that would respond to your inquiry. Our argument that the statement was not reliable under the evidentiary standard is based on primarily on inconsistencies between what Calabrese said and, for example, the medical evidence or physical evidence.
But what difference does that make as it relates to your defendant? I mean, if the medical evidence was different, what was Calabrese lying about it in your view, or that's my question.
Well, the trustworthiness of the statement is assessed based on the totality of the circumstances as a whole, the whole statement. So the court looks at the various consistencies or inconsistencies to make an ultimate determination on whether the whole statement comes in.
Okay.
So with respect to the primary purpose test, we're asking you to, thank you, we're asking you to apply Supreme Court precedent, particularly Bryant, which looks at all of the circumstances of this encounter. This was a police-initiated encounter. I don't think there's any question about that. And in terms of the client, certainly he knew, like any reasonable inmate would know, that his statements could, at some point in the future, be used against him. Now, in terms of the state constitutional argument, I don't think I have anything particularly to add to that. I think I would like to spend the few minutes I have remaining to talk about the fourth issue, which involves the trial court's exclusion of a statement against penal interest that was exculpatory to the defendant. I'm not going to talk about the merits, the trustworthiness of that statement, because I think that's been briefed at length. But I want to talk about the issue of unavailability, which is an essential requirement in order to get the statement against penal interest into evidence. When this was first being discussed in front of Judge Danaher raised the issue of whether or not Sham Patel was available. And the first action that defense counsel took was he actually sent a text message to Sham Patel's attorney. I see I have 3 minutes left. Attorney Fitzpatrick. And he gave a flippant answer back. When Judge Danaher made his oral ruling excluding Sham Patel's statement, the ruling lasted for about 10 pages. When he finished his ruling, defense counsel made another comment, and it's the second to last page of part 2 of our appendix on page A806. Attorney Dow says, I did get a call back from Mr. Fitzpatrick who said his client would not testify. And Judge Danaher says, I accept that. Those are his first 3 words, I accept that. So our position is, once the judge said that to Attorney Dow could reasonably believe that he had satisfied the unavailability requirement, that the court agreed that had been satisfied. What happens is, defense counsel files a motion for new trial. It's denied orally on the day of sentencing, and Judge Danaher says he'll issue a subsequent written ruling, which he does 2 months after sentencing. Judge Danaher issues a ruling where he says that the defense did not establish the unavailability. Now, at that point, effectively, Attorney Dow is working on another case. His client was sentenced. I had been hired for the appeal at that point, but I didn't have the transcripts. So his ruling meant nothing to me at that point in time. And we take the position in our reply brief that it would be unfair to claim or agree that Attorney Dow failed to establish unavailability in terms of what happened when he reported as to what Attorney Fitzpatrick had said, and Judge Danaher had said, I accept that. I see that my time is up. Thank you.
Attorney Emanuel, there's a question from Justice Khan. You muted, Justice Khan. No, you just muted yourself again. Now
Okay.
you're not.
Very sensitive cursor. I apologize. Counsel, my question is precisely on this issue. I thought that after getting an indication from counsel that the witness would invoke the Fifth Amendment, that actually there was a hearing in court where the questions were asked of counsel in the presence of the defendant, and that Judge Danaher went further and after there was an objection from defense counsel and specifically asked the witness, although not putting him under oath, said, is it true that you will invoke the Fifth Amendment to each and every question asked of you? Did that hearing take place, or am I confused about the record?
No, that took place with respect to Michael Calabrese. He was brought into court and he invoked his Fifth Amendment, and therefore Calabrese was unavailable, which enabled the state to bring in his tape recorded statement. But that did not happen with respect to Shyam Patel.
Thank you, counsel.
Thank you, Mr. Emanuel. You have your remaining time. Counsel, you ready to proceed?
May it please the court, my name is Matthew Weiner. I'm an assistant state's attorney with the Office of the Chief State's Attorney, and I represent the state in this appeal. I'll begin, Your Honors, with the defendant's federal claim, and just I think that maybe I need to clarify the state's position here. It is the state's position that this court is bound by Supreme Court authority with respect to the claim that comments like those that were at issue in this case violate the Confrontation Clause, and the reason for that is that I think it's undisputed that in Dutton and later in Borjali, but specifically Dutton, where what we have is a retrospective description of a crime or dual inculpatory statement that a co-defendant makes to a cellmate, that is found to not violate the Confrontation Clause. And then fast forward to Borjali, where we have, again, a statement made to a FBI informant, similar to this case, where, again, the Supreme Court holds that there is no Confrontation Clause problem. We fast forward to Crawford, and as I understand the defendant's argument is that Crawford changed everything, essentially. And that is true. I agree with Justice Khan. Certainly, this was a sea change in the mode of analysis. But importantly, what the U.S. Supreme Court said in Crawford was that although our analysis has changed, the outcomes that we reached specifically in Dutton and Borjali would have been the same. That is, and this is from Davis, those cases dealt with, quote unquote, clearly those statements were clearly not testimonial. So again, so the question for this court is whether Calabrese's statements, which are similar to those in those two cases, is testimonial or not, and the Supreme Court has answered that.
Justice Ecker.
I hear you, and I get that. Although, as I read Crawford, I think Justice Scalia's point was that the outcome in those cases was correct, but the rationales were flawed. And I don't know how that cuts in terms of Bourgeois and Mr. Emanuel's point. My question was on something slightly different, which is this, and I don't know if anybody else has this concern, so I'll try to get in and get out. What I was concerned about was what appeared to me to be the state action really behind this entire episode. Not only with respect to the confidential informant and the fact that he was essentially an undercover agent of the police, but also the point raised in your opponent's brief about the potential manipulation of trial order. By trying Calabrese last, they prevented the state, prevented cross-examination of him in court and took away the confrontation clause. If you had tried him first, he wouldn't have had, at least according to Mr. Manuel, he wouldn't have had a right to, he would have been at trial and been cross-examined. And that concerns me. And I can, I guess you could say, well, that's your problem, Judge Ecker, but it does, I did see in the cases, and particularly in Washington, Davis against Washington, is it not Washington against Davis? But, a concern about the police evading the requirements of the confrontation clause. And I think they use the example, you can't keep it really informal and not reduce the statement to, an affidavit form in order to avoid confrontation clause problems. And that's repeated in another case, I think. Here, what about that? I mean, why isn't this an evasion of a deliberate, or at least objectively speaking, seems to be a deliberate evasion, attempt to circumvent the confrontation clause?
Well, I think, Your Honor, first of all, there's absolutely no evidence supporting the defendant's allegations here. Yes, it is true that Niraj Patel.
Well, there's a lot of circumstantial evidence, which is what often the state relies on to prove things. There's a lot of circumstantial evidence.
Well, Your Honor, I respectfully disagree. That the circumstantial evidence, it seems to me, is the order itself. There are any number of reasons, and I personally do not know why, but there are any number of reasons, including the schedules of defense attorneys, as to why the case these three cases would have gone in the order that they did. So that I think is the fundamental problem. I don't disagree with Your Honor. That is certainly that concern. I think, from the case law, there is a concern there about police manipulation and state action, but that is not before this court in this case, because there's simply no record supporting that.
Thank you.
Justice Daria.
It seems like from what we've been presented, there isn't much of a record. I guess I don't know if I should expect you to know what happened in the other cases. I'm not sure. I think a lot of folks would. Tell me if I'm wrong. He got 20 years, Calabrese. He shot the guy and he didn't testify in any of these cases. So I think some of us are going to struggle with understanding why that case was done last. And, nobody gets to cross-examine Calabrese, and then this gentleman doesn't get to make his declaration against penal interest argument through sham. Tell me why I shouldn't be worried about sort of the whole ball of wax.
Well, Your Honor, first of all, I will certainly look into this. My understanding was that Calabrese got the most time. My understanding, I thought, was that Calabrese I believe this defendant essentially got 35, Niraj got 45, and I thought Calabrese got 45 or 50. If I'm wrong, I'll certainly.
And I may be wrong. I'm not sure I know how to read all these things on databases, so I could very well be wrong. Mr. Emanuel might know.
And so, yeah, so in that case, I mean, certainly there was no agreement with Calabrese, and that's why it would be surprising to me if in fact Your Honor is correct that he got 20 years, because he didn't provide the state with anything in this case, or what I'm familiar with anything anywhere. So that's why my understanding was that he got the most time, because, as Your Honor, that he was a shooter.
So then could you respond to the question I asked Mr. Emanuel about trustworthiness, about Calabresi's statement as a declaration against penal interest? I mean, it's your burden to show, the state's burden to show that it comes in, right? It's trustworthy. Yeah. There's a whole lot of indicia of reliability as to the fact that Calabresi was in the house and shot this guy. You know, there may be a lot of inconsistencies a year later or whatever. You know that the defense is alibi. Is there anything that the state pointed to say that it was trustworthy vis-a-vis somebody else that was allegedly in the house? Or is it just, you know, all the things that Calabresi said about how it went down, and then he also points to this Patel and not the other Patel?
Well, I think, Your Honor, there's at least two pieces of evidence that support the idea that his pointing his finger at the defendant in particular was trustworthy. Number one is the fact that he identified the defendant. Well, he told, before the actual murder, before the shooting, he told his girlfriend, Colwell, that he was going up to Litchfield County with the defendant to rob a kid. And so he's implicating the defendant before. And then, of course,
they're all in the area.
Well, yes, and that's what Your Honor had asked about, the alibi defense. So that's what, you know, to the extent this was a question for the jury: was the defendant in Litchfield or was he in Boston? Calabresi simply puts the defendant in Litchfield before any of this happens. And then, of course, there's all the cell phone evidence, both the location data as well as the communication data, that puts the defendant, or that establishes the defendant as a co-conspirator in this conspiracy to rob.
And you can use that to bring in, I mean, that's independent evidence that may corroborate it. But when you're putting in the trustworthiness of the statement, you can look at that?
Yes, Your Honor, because I think historically, when it came to the old Ohio versus Roberts test, that was where you couldn't use external evidence under the guarantees of trustworthiness for corroboration. But on the evidentiary question, you can use corroboration. In fact, our jurisprudence is littered with examples where, you know, in a lot of cases, that decision as to whether it was trustworthy or not rose and fell on the basis, or on the amount of corroborative evidence there was in the case. Again, corroborating the statements.
And the cell phone evidence was already in?
Yes. Well, I mean, it was already coming in because that was litigated pre-trial as well. And so I believe.
I see your point. Certainly your point is valid as it relates to the, you know, rebutting the alibi. But if the question is which Patel was in the house, I mean, all their cell phones are going to be in the area, and you know, the mother in the house thought it might have been Cheyenne. So you still think it's trustworthy enough for him to point the finger? I mean, it's not coming in as to him, Calabresi. It's coming in as to somebody else.
Well, it is, Your Honor, and I'd just like to point out, because I know the defendant makes the argument, I believe in his reply brief, about the mother's statement. She did not identify Sham as one of the assailants. What happened was that there was a stipulation that essentially said, in the time following the incident, she gave multiple statements in which she indicated or provided multiple descriptions. First, it was two white men. Then they were Hispanic. Then they were Indian. She thought one might be Sham. And then she said no, she had no idea. So I think that is a far cry in terms of evidence that would undermine the trustworthiness from the evidence, the hard physical evidence, the cell phone data, and everything else that does in fact corroborate not just Calabresi's involvement, but also the defendant here's.
Thank you. All set.
Thank you, Justice Daria. Justice McDonald.
Thank you. Counsel, I'm trying to, even after reading your brief, I'm not entirely clear how this recording doesn't fit the two-part primary purpose test of Davis. So could you just try to synthesize that for me? I mean, it certainly wasn't an ongoing emergency. So really focus on the second part of the test.
Right. And so I think what Davis, as I understand the case law, and as I understand, quite frankly, this court's jurisprudence with Walker and Sinclair, essentially, the court must consider all of the factors or all of the evidence and all of the facts and circumstances when deciding the primary purpose. However, when essentially there is no reasonable dispute that the declarant did not have the purpose to provide, essentially a substitute for testimony, well, that's the controlling. That is essentially dispositive. And so here, that's what we have in this case. If we didn't have that, like let's say this court has dealt with the tender years exception, State versus McGuire, where maybe you have clear law enforcement involvement on one side of the equation, and we don't have evidence as to the declarant's intent whatsoever. Maybe it was law enforcement related, maybe it wasn't. Well, in that circumstance, maybe the second part of the equation will control over the first. But here, and to answer, I've forgotten who asked the question, but I am not familiar with any case anywhere, state or federal, where a statement has been held to satisfy the primary purpose test, even though the declarant had no idea, essentially, or no intention at all for it to be a substitute for testimony.
Well, I mean, how would you distinguish that situation that you've just articulated from a situation where somebody gets called in for questioning in a police department? Are you really suggesting that the person who gets called in to the police department to talk to the police is contemplating that what they're going to say is going to be used in their trial? Well, even if they may be trying to get out of getting charged altogether. That may be their purpose of talking.
Exactly, Your Honor. And so it doesn't necessarily have to be an identifiable person. And I'm not going to, and that's what this court has, when this court has rejected the Williams, Illinois case and kind of gone back to the primary purpose test. So there doesn't have to be an identifiable person, a target, for the purposes of the Confrontation Clause. So in that circumstance, Justice McDonald, absolutely, the person is going in, knowingly speaking to law enforcement. They're probably, if they're providing exculpatory evidence, then they are absolutely hoping that that statement is going to be used as part of the criminal investigation, because they're hoping that that statement itself will get them out of whatever it is they're potentially being investigated for. So that's very different than this situation, where what the defendant basically admits to are crimes that will give him a life sentence.
What weight do we put, I understand that, but what weight do we put on the other side of the equation? The test says, and that the primary purpose of the interrogation is to establish or prove, past conduct. What weight do we put on the primary purpose of the interrogator?
Well, I think it depends on the circumstance. So there might be, like in State versus McGuire, a lot of weight that goes into that side of the equation where there's uncertainty on the other side. But in State versus Sinclair, and this is this court's most recent decision on this issue, here you had a police investigator, the Waterbury Police Department. Somebody reaches out from the Waterbury Police Department clearly for the purpose of conducting criminal investigation to a New York police officer. That New York police officer basically translates a business record. And this court concluded that because the New York police officer would not have objectively believed that that relatively innocuous information, the conveying of that relatively innocuous information, was part of the criminal investigation, essentially the declarant, again, controlled, notwithstanding the listener's intention.
Okay. I mean, I understand that. I'm just struggling with, it doesn't say the primary purpose of providing the answers is to establish, it's the primary purpose of the interrogation, right? I mean, the declarant didn't create the primary purpose of the interrogation, did he?
Well, I mean, I guess I don't read the case law as suggesting that there has to be an overall primary purpose of the interrogation, because, well, I mean, I guess there is.
That's the actual language. You literally just quoted the actual language of Davis.
But again, it begs the question of the interrogation from whose perspective. Because again, the point of this test is to determine, again, whether this is testimonial, whether this was essentially intended as a substitute for trial testimony. And so if the declarant had absolutely no intention or no belief that this was going to end up as a substitute for trial testimony, the state's perspective, and under Sinclair, it's almost irrelevant as to what the other side of the equation was thinking at the time.
I'm just, okay, I appreciate that answer. I'm wondering if we got it right in Sinclair, but okay, thank you.
Justice Khan.
Thank you, Chief. Counsel, I know that you earlier indicated you don't know how the order of the trials occurred. Judge Danaher was not the presiding judge, correct?
In Litchfield at the time, that I'm not sure, Your Honor. I know he obviously he
Well,
sat.
I mean, if he was the trial judge, he wouldn't have been the
Right.
presiding judge, pre-trial judge.
Yes.
They were charged separately. All three were charged separately, I'm assuming.
Yes, and they were arrested together, but charged. Yes, they're yes, Your Honor.
Okay. You know, and I think it may have been also your opponent in response to a question of who goes first. Some of that is also determined on the defendant, right? Defendant and defendant's counsel. I mean, there could be reasons why somebody would go second or first, correct?
Absolutely, Your Honor. And it could have to do with their defense counsel's schedule, individual schedules.
Now, in terms of trial strategy, would it be, in terms of raising a Crawford issue, for example, it would be better for a defendant if who was raising a Crawford issue, if he or she went first and that other person still had a Fifth Amendment right. Otherwise, there would be no Crawford issue. If they didn't have the right to invoke the Fifth Amendment, presumably they would be available. And if they're available, then there's no Crawford issue, correct?
That's correct, Your Honor. I mean, I think there's a lot of dots to be connected there, but in the abstract, that is correct, Your Honor, yes.
And my final question is, it's my understanding that Calabrese actually pled guilty in this case, correct?
Yes, Your Honor.
And I think his sentence was 55 years. Is that, I think that's
my selection.
Okay.
Yeah, but I will certainly correct the record if I am wrong about that.
Okay. But you do agree then that in terms of strategy, there's certainly strategy on both sides, who goes first. And that can happen a lot in multi-defendant cases, correct?
Yes, Your Honor.
Thank you. I'll yield back to my colleague. I think Justice Ecker has.
Justice Ecker.
Thank you, Chief. I have two questions, or two areas, hopefully two questions. But one is just, on going back to Justice McDonald's line of questioning about sort of purpose from whose perspective, I mean, if you take the reliability, sort of the pre-Crawford framework, and if reliability still matters, if the inquiry really is about the trustworthiness or the reliability of the underlying statement, declarant statement, then I could see why you'd say, well, it's the declarant's perspective that's primarily important. And there's definitely suggestions in some of the post-Crawford case law that's what matters. They still say, well, the hearsay exceptions, I mean, Ohio against Roberts isn't dead in that sense. On the other hand, if you go back to some of Justice Scalia's reasoning in Crawford, it's really about who is a witness. And, whether they're a witness, because he uses the, original intent and the constitutional text and all that. And it's pretty hard to say from that perspective that Calabrese was not a witness. He was not being used as a witness from the get-go here. He didn't know it, but everybody else did. The state did. And so, I mean, Calabrese didn't know it. I'm sorry. But so, you see what I'm saying? I mean, why isn't that a proper analysis?
Well, I think, Your Honor, I think Justice Scalia actually himself answers that question in his dissent, joined by Justice Ginsburg in Michigan versus Bryant, that it's a matter of a witness is somebody who bears testimony. Making a comment to a cellmate or even telling a story to a cellmate is a far cry from offering testimony under oath in court. So
from the declarant's perspective, but this was bearing testimony from everybody other than the unwitting declarant from the get-go. That's my point, and that's my question. But I'll look at that dissent because I'm aware of it, but I must confess I haven't read it, and I assume there's an answer out there. If I may, just because I have one question on the other fourth issue, I think it is, and that's this. The analysis that the judge undertook on trustworthiness of the statement really focused on Shyam's the trustworthiness of Shyam's statement, right? And that's, I guess, the way it's supposed to work. It's just weird because in this case, look, if he said it, it was trustworthy. I mean, why would a person confess to a murder? If to his sister, if he didn't do it. I mean, I can see why, so, I mean, the real question here, the real question about that out-of-court statement was about whether the sister was making it up to protect her brother. And she would have been in court. And the jury could have, the fact that she's a sister, it all goes to weight, and the jury could have assessed that. So why doesn't it sort of miss the point, the analysis that was undertaken by Judge Danaher here?
Well, I think my answer is in two parts, Your Honor. First, I do think, and it's perhaps easiest to compare this to the Calabrese statement, but there were indications that even if Shyam had made those comments, there was a reason to doubt their veracity. So, for example, the conversation began with two things. Number one, Dr. Majmudar saying, I know my brother's innocent. He wasn't there. He was with me. Number two, so she's already led him to the conclusion that he provides her. Number two, it's clear, the record is clear that he's asking for something rather substantial from her. So he's asking for $50,000. So he has an incentive to try and tell her. And in fact, at the end of that proffer, she testifies that yes, Shyam told her exactly what she had already believed. So essentially, there's evidence that even assuming that he did say these things, that what he's doing is trying to manipulate her and tell her, things that she wants to hear in order to hopefully extract something of benefit, which he is desperate for. On the other side, the second part of the answer to your question, Your Honor, is that this court has in the past considered essentially, the likelihood or the possibility that something was fabricated in deciding, especially whether a third-party exculpatory statement is trustworthy or not. And I'll just give a handful of cases. Sanchez-Rosado talk about the Sanchez and Rosado talk about the possibility of fabrication, and that in one circumstance, I believe it's the defendant's sister making the comment, claim of responsibility. And another, I believe it's the actual, again, similar to this case, the defendant's alibi witness who later claims that also somebody else claimed responsibility. And then I guess a little bit more indirectly, I refer the court to Gold and Smith. In Smith, this court looked to the fact that the statement was audibly recorded as a sign of trustworthiness, and Gold looked to the fact that somebody else heard it secretly being said.
Thank you.
Justice Doria.
At one point in your brief, you mentioned that the record's not clear between the two trials as to whether Mr. W initiated or the state did, the police did. And I guess, this isn't a Messiah case, so maybe the issue just didn't really come up. But I guess, again, I'm sort of wondering, the state, I would think, knows. And in this case, it was the fact was that he testified that the police came to him about it. Is your view just that it doesn't matter in this instance for reliability purposes, or why did you care that we thought it was uncertain as to who did what?
Well, I think that, again, I guess my answer to your Honor's question also will be in two parts. Number one, it doesn't matter, right? And that's, from the trial, as the trial court indicated, as the appellate court indicated, this court's jurisprudence is very clear that it's the declarant's perspective that counts, or that matters most, I should say. And so the parties and the two courts, relying on that case law, litigated the case the way they did and made the decisions they did. But in terms of the substance of your Honor's question, I think I'm pointing out the fact that it's not clear. And so, for example, in addition to Niraj's trial, there's this trial, and there's also a petition for a new trial. At the petition for a new trial, there was testimony not only from the CI, but also from the state police officer who had the phone conversation. And I think, the defendant in this case has argued that this was all a concoction of the prosecutor and the state police. Again, I understand it's outside the record, but in that petition for a new trial, that was not the testimony provided by the state police officer there. And so that's why I say if the defendant is going to be permitted to raise this type of claim for the first time on appeal, it's incumbent on him to make sure that the record is unambiguous as to the facts that he's relying on, and he hasn't done that here.
Okay. So in this, I mean, it may be outside this record, but you're telling me that there are parts of other records where what is the state's position that that Early came to them?
Well, I don't want to say it's the state's position that Early came to them. I think his testimony itself is conflicting on that point. I think what I'm more focused in on is the allegations that the state police, and therefore the state, rather than DOC, was the party that essentially set all of this in action. That it was that investigatory criminal justice, Division of Criminal Justice, essentially, that was involved. That's where I think there's, and again, I think my point at the outset is that it doesn't matter in the context of the claims that he's raised here. It clearly doesn't matter for the purposes of resolving the federal constitutional claim, and it shouldn't matter for purposes of resolving the state constitutional claim, because if this court were to go down the road of basically holding that it's the listener's intent that controls, not only is it going to eliminate reliable, trustworthy evidence in criminal cases, but it can have an impact on other hearsay exceptions. And I'm thinking specifically of the medical testimony, or the medical exception.
Justice Khan.
Thank you, Chief. I share Justice Doria's concern, and I think he raises a very good point. I thought I read somewhere in the record that for purposes of the Calabrese statement, that the lawyers in this case asked the trial judge to take judicial notice of Niraj Patel's trial and Early's testimony in connection with that. Did I read that accurately?
Well, yes, I think what the yes, at the beginning, if I see my time is running out, but if I can just provide a short explanation. At the beginning of this trial, the defendant filed basically a virtual copy of the motion that was litigated in Niraj's trial. The defendant also asked the trial court to take judicial notice of all of the transcripts and filings in Niraj. And essentially at that point in time, Judge Danaher asked the defendant, well, look, I've issued a written decision on this issue. Is there anything since, facts or law, that should cause me to reconsider that decision? And the defendant said no. He said, all right, well, then I'm essentially incorporating that decision.
Right. And that's the part that I read. And so just a very quick follow-up. The information that you just provided in response to Justice Doria's question, was that part of the testimony in Niraj Patel's trial, or just part of what's being argued on a petition for a new trial? Do you see what I mean? Was that included in what the trial judge took judicial notice of, or was it an after the fact statement? So
the state detective was after the fact. Early's testimony that I went to them was in Niraj's trial.
Okay, thank you. Thank you, Chief.
Anything else, Attorney Weiner?
Well, I didn't touch on harmless error. If I may have 30 seconds to just make a point about the record, Your Honor.
You may.
And I just wanted to highlight the defendant's harmful error argument in his reply brief is premised on the notion that the state had to prove beyond a reasonable doubt that the defendant, Haral Patel, was inside the home. I just want to point out to the court that this was charged, the murder charge was charged as Pinkerton. So what the state had to prove there was that the defendant was involved in the conspiracy, robbery, burglary, and that the murder was essentially a foreseeable result. The evidence was overwhelming on those points, and I'd specifically refer the court to Calabrese's statement to Caldwell, as well as the cell phone evidence. Thank you, Your Honor.
Thank you, counsel. Attorney Emanuel.
Your microphone is muted, sir.
Thank you. Just a few brief points. With respect to harmless error, I would simply point out that approximately the first 10 pages of the state's closing argument, pages in our appendix A679 through A689, are spent referring to, summarizing, and quoting from Michael Calabrese's statement. And the final sentence in closing argument is this. The prosecutor says, quote, "I would respectfully suggest that the statement of Michael Calabrese alone proves up all of the elements of this case." So we think it's clear that harmless error is not involved in this case. With respect to what happened to Michael Calabrese, he did plead guilty. He was sentenced in August of 2018 to 55 years. Now, with respect to the primary purpose test, the 6 key words, quote, "the primary purpose of the interrogation," they appear twice in the Davis definition of both non-testimonial and testimonial. You cannot look only at the declarant's purpose or intentions. Brian says you have to look at everything, and that includes the interrogator's purposes and intentions. There is no question this was a police-initiated operation. What happened was, it was Tuesday, September 3rd. DOC officials call Wayne Early into their office. They tell him they are going to move Michael Calabrese into his cell that night and ask Early if he'd be willing to record him. Early says yes. The two men meet for the first time at 10:30 that night on September 3rd. They say a few words each about why they're in prison, and then Wayne Early testifies that he stopped the conversation because he knew he'd be wearing a wire the next day and didn't want to create any suspicion. The next afternoon at 1 o'clock, DOC officials bring Early into the office and they say, "Are you still willing to wear this wire?" He says yes. They send him out into the day room, and then they call a lockdown. That, I think, is a pretty incredible fact. They plan to call an institutional lockdown at Whaley Avenue to facilitate an interrogation by an informant who's acting at the behest of the police. The lockdown's called, the two men go back into their cell, and then the 2-hour conversation ensues. And we have a transcript of that was provided to the jury. I counted over 200 questions that were asked by Wayne Early. I stopped counting at 200. So this is not a situation where someone is just making, offhand statements or comments.
Attorney Emanuel,
Yes?
I'm sorry to interrupt. I've been trying to get your attention for a while now. Justice McDonald has a question.
Well, I think you I think you just answered it. Was the entire 2-hour interrogation played for the jury?
Yes, it was.
From beginning to end?
From beginning to end. The transcript was 49 pages, but they did delete a few sections that were kind of irrelevant from the transcript. But yes, the whole recording was played.
Thank you.
That's my understanding, and based on the transcript, and I've also listened to the tape. I see I have 1 minute left.
And you have a question from Justice Doria.
Yeah, I just want to ask you though that so that's a very, that may be a powerful claim for Calabrese, but again, I'm getting to why is that affect not just standing wise, but what he had to say about your client? Why does that make it questionable in any fashion?
I'm not sure I understand the question.
Okay, look, so whether if he was charged with the claim, it would be, sounds like it would be an airtight Messiah claim, but it's not. You explained that to us because he wasn't in custody on that. They didn't know he had counsel, and so maybe you said he had a due process claim of some sort. Okay, that's awaiting his trial at the end of everybody else getting tried, I guess. But why does that undercut? Why does the state action there undercut any reliability as it relates to your client? I mean, it may be dirty pool as it relates to Calabrese, but the rest of what he's talking about, there's no constitutional violation other than Crawford. You're making that argument, but he doesn't have a third-party Messiah claim. He just has declaration against penal interest. And I'm just wondering, once we're looking at that whole confession, so to speak, by Calabrese, why does that undercut which Patel was in the house with him?
Oh, I think I see what you're saying now. That's with respect to the evidentiary claim. And I don't think it does undercut. I don't think it does.
Okay.
You may wrap up, Attorney Emanuel.
Thank you. I have been representing Haral Patel now for close to 4 years. I think it's 3 3/4 years. And I still have difficulty sometimes wrapping my head around the fact that you can be convicted of crimes as serious as murder and home invasion based on a recording that is played at your trial in which you are powerless to cross-examine. I think defense attorney William Dale summed it up pretty well when he told the jury, quote, "The foundation of this case rests upon a guy you never saw," close quote. The jury heard Calabrese's voice. They never saw him, never saw his demeanor, never saw him cross-examined, and of course, he was not under oath. This case, I think, has taught me the importance of the confrontation clause and what a deprivation of confrontation rights can do. I'd like to thank the court for your attention, and I apologize that I wasn't earlier. I did not recognize there's a symbol for when a hand is up, and I apologize to all for that. I see it now.
Counsel, I'll take responsibility for that. I normally try to tell folks that how we ask questions here, and I do apologize to you for not telling you that information. Justice Doria, did you have another question? All right, well, thank you very much. We will be in recess until 11 o'clock. We'll then hear the matter of Pfister versus Madison Beach. We are in recess.